Welcome to episode 7 of Family Court Uncensored series. Today we're breaking down Practice Direction 12J, the court practice direction that governs how domestic abuse allegations are handled in family proceedings. If you're facing allegations in family court, or if your partner has mentioned any concerns about your behaviour, you need to understand Practice Direction 12J, because this single piece of guidance has fundamentally changed how fathers are treated in family courts. Practice Direction 12J was introduced in 2008 and significantly updated in 2017 and again in 2021. It provides guidance to judges on how to handle cases involving domestic abuse allegations. On paper, it exists to protect genuine victims of abuse and ensure their safety during family proceedings. In practice, it has become a procedural weapon that adds 6 to 12 months to your case, costs thousands of pounds, and operates on the assumption that allegations are credible until proven otherwise. By the end of this episode, you'll understand what triggers Practice Direction 12J and how the fact-firing hearing process works, why defending yourself is nearly impossible under the current framework, and what strategic decisions you need to make if you find yourself facing this process. This is essential knowledge for any father in scenario 2 or 3. Let's start with what Practice Direction 12J actually is. It's a practice direction, which means it's guidance issued by the courts to judges on how to handle certain types of cases. Practice directions sit below legislation and case law in the legal hierarchy, but judges follow them closely. Practice Direction 12J specifically deals with child arrangement cases where there are allegations or evidence of domestic abuse. The 2017 update was significant because it explicitly incorporated the concept of coercive control, which we discussed in episode 9. Remember that Section 76 of the Serious Crime Act 2015 created the criminal offence of coercive control. Practice Direction 12J brought that framework into family court proceedings, requiring judges to consider patterns of controlling or coercive behaviour when assessing domestic abuse allegations. Here's what triggers Practice 12J. If either party makes allegations of domestic abuse, or if the court has reason to believe domestic abuse has occurred based on information available to it, Practice 12J applies. This is important. You don't need proven abuse or even detailed allegations. The mere raising of concerns about domestic abuse brings back the entire Practice Direction 12J framework into play. So what counts as domestic abuse under Practice Direction 12J? The definition is extremely broad. It includes any incident or pattern of incident of controlling, coercive, threatening behaviour, violence, or abuse between people who are or have been intimate partners or family members, regardless of gender. The abuse can be psychological, physical, sexual, financial, or emotional. Notice how broad it is. Any incident or pattern of incidents, controlling or coercive behaviour, which, as we discussed in episode 9, can include asking where your partner is going or expressing an opinion about spending. Threatening behaviour, which could be raising your voice during an argument. This breadth is by design intended to capture all forms of abuse, but in practice it means almost any relationship conflicts can be defined as domestic abuse if one party chooses to do so. When Practice Direction 12J is triggered, the court must conduct what is called a fact-finding hearing. This is a separate hearing before the main hearing about contact arrangements, where the court determines whether the abuse actually occurred. The fact-finding hearing is where allegations are tested, evidence is heard, and the judge makes findings of fact about what happened during the relationship. The standard proof at a fact-finding hearing is the civil standard, balance of probabilities. This means the judge needs to be satisfied that it is more likely than not that the abuse occurred, not beyond reasonable doubt like in criminal court, just 51% likelihood. If the judge thinks there's a 51% chance you did what's alleged, the finding goes against you. Let's talk about how the fact-finding hearing process actually works, because understanding the mechanics is critical to understanding why this system is so difficult for fathers to navigate. First, allegations are set out in what's called a Scott schedule. This is a table format where the mother lists specific allegations, date, what allegedly happened, her account of the incident. You then respond to each allegation in the adjacent column. Admitted, denied, or denied with alternative account. The judge uses this schedule as the framework for the hearing. Here's the problem. The Scott schedule formatting encourages a voluminous list of allegations. There's no practical limit on how many incidents can be included. I've seen Scott schedules with 50, 70, or even over 100 separate allegations spanning years of a relationship. Each one is an argument you had, a text message you sent, a decision you made, reframed as evidence of abuse. Why does the mother solicitor include so many allegations? Because it overwhelms your ability to respond. You're expected to remember and provide detailed responses to incidents from 3, 4, 5 years ago. What was said in an argument in March 2021? What was the context for that message in June 2022? You're being asked to defend yourself in a comprehensive rewrite of your entire relationship, presented with the lens of coercive control. The second problem is how allegations are characterized. Remember from episode 9 that coercive control is defined by patterns of behavior that make victims subordinate or dependent. Individual incidents that seem minor on their own are presented as part of a pattern. That text message argument about money, pattern of economic control. That disagreement about going out, part of a pattern of isolation. The Scott schedule strings together dozens of incidents, each arguably minor, to create a narrative of systematic abuse. At the fact finding hearing itself, both parties give evidence. Mother goes first, presenting her account. She's questioned by your solicitor if you have one, or by you if you're representing yourself. Then you give your account, you're questioned by her solicitor and potentially the judge. Here's the third problem. Cross-examination is heavily restricted when there are domestic abuse allegations. The court is required to consider the impact of cross-examination on the alleged victim. If the mother claims she's afraid of you or traumatized by your abuse, the court may limit how you can question her. Special measures might be used, screened so she doesn't have to see you, video links so she gives evidence remotely, intermediaries to help her answer questions. These protections are appropriate for genuine victims of serious abuse, but they're applied routinely in all cases where Practice Direction 12J is triggered, regardless of the severity or credibility of allegations. The result is that your ability to challenge her account is constrained from the start. You're not allowed to be aggressive in questioning. You must be measured and respectful, but she's allowed to be emotional, to break down, to claim she's too distressed to answer. The playing field is not level. The fourth problem is the evidence standard. The mother's account of how your behaviour made her feel is treated as evidence, as we discussed in episode 9. If she says she felt controlled, subordinate, isolated, that subjective description is given weight. Your account of the same incident is treated skeptically. If you say arguments were mutual, that's minimising. If you say you weren't trying to control her, that's lack of insight. If you provide alternative explanations, that's being defensive. The judge is required under Practice 12J to consider whether your behaviour amounts to a pattern of coercive and controlling behaviour. Individual incidents are assessed not in isolation but as part of an overall pattern. This means even if you successfully defend against specific allegations, the judge can still find that taken together your behaviour constituted coercive control. Let's talk about what happens at the fact-finding hearing, because the findings have massive implications for the rest of your case. If the judge makes findings of domestic abuse against you, those findings are treated as established facts for the rest of the proceedings. The court will then conduct a risk assessment to determine whether contact with you poses a risk to your child. Under Practice Direction 12J, if domestic abuse is found, the court presumes that contact may not be safe unless protective measures are in place. Protective measures might include supervised contact at a contact centre, which you pay for at around £30 to £50 per hour, more in London. No overnight contact. Phased reintroduction of contact starting with short supervised sessions, requiring you to complete domestic abuse perpetrator programs before contact progresses. All of this adds months or years to restoring normal contact and costs thousands of pounds. If findings go in your favour, meaning the judge doesn't find that abuse occurred, you'd think that would end the matter. Sometimes it does, but often, even when specific allegations are not proven, the judge still expresses concerns. Maybe the judge finds that abuse hasn't been proven to the required standard, but there were clearly difficulties in the relationship. Maybe the judge doesn't find coercive control, but finds that arguments were heated and concerning. These softer findings still affect the contact decision. Here's the strategic problem fathers face. The fact-finding hearing is expensive and time-consuming, but avoiding it may be worse. If allegations are made and you don't contest them, they're treated as admitted. If you try to settle by agreeing to supervised contact to move things forward, you're implicitly accepting that supervision is necessary, which reinforces the narrative that you're a risk. But contesting every allegation in a fact-finding hearing costing thousands of pounds in legal fees if you have a solicitor takes 6 to 12 months to get a hearing date and requires you to relive and defend every argument you had over years of relationship. It's emotionally devastating, financially ruinous, and uncertain in outcome. Let me explain how Practice Direction 12J is weaponised strategically, because understanding the tactical use of allegations is important. Timing is everything. Allegations are often made at strategic points in proceedings. Most commonly, they come after the first hearing dispute resolution appointment, when it becomes clear you're serious about pursuing contact. The mother's solicitor advises that raising domestic abuse concerns will trigger Practice Direction 12J, which delays everything and puts you on the defensive. Sometimes allegations emerge after a period of informal contact that was working reasonably well. And why? Because if contact is proceeding without incident, that undermines any claim that you're dangerous. But if allegations are raised before good contact can be established, there's no track record of safe contact to point to. The volume and vagueness of allegations is also tactical. A Scott schedule with 70 allegations spanning 5 years is designed to be overwhelming. You cannot possibly remember and respond to every incident in detail. Your response will necessarily be general or incomplete, which makes you look evasive or unable to take responsibility. Vague allegations are particularly difficult to defend against. He frequently makes me feel controlled. How do you disprove a feeling? He would get angry when I wanted to see friends. When? Which friends? How angry? What did he actually do? Without specifics, you can't provide a detailed defense. But the vagueness itself makes the allegation hard to dismiss. The coercive control framework makes this worse, because every coercive control is about patterns rather than specific incidents. Even if you successfully defend most allegations, the remaining ones can be characterized as a pattern. You might prove that 20 of 30 allegations are false or exaggerated, but the judge can still find that the remaining 10 demonstrate a pattern of controlling behavior. So what evidence actually helps in the fact-finding hearing? This is crucial practical guidance. Evidence that helps. Contemporaneous records. If you kept a diary during the relationship, that's gold. Text messages or emails that show the context of arguments or the mutual nature of conflict. Witnesses who observed your relationship. Friends, family members who can testify that they never saw controlling behavior or that relationships seemed equal and arguments were mutual. Character references are useful but limited. Letters from employers, friends, family saying you're a good person help establish that allegations are out of character, but they don't directly disprove specific incidents, so their weight is limited. Evidence of her behavior is important if you can get it. If she was controlling, abusive, or engaged in the same behavior she's accusing you of, that context matters. Text messages showing she monitored you, controlled spending, dictating who you see. These demonstrate that control was mutual or that you were the victim, not the perpetrator. Evidence of the timing of allegations matter. If allegations only emerged after you filed for contact or after she found a new partner, that timing is relevant to credibility. If there were no complaints to the police, no medical records, no contemporaneous evidence of abuse during the relationship, that's relevant. Evidence that doesn't help as much as you think, your testimony. Obviously, you need to give your account, but your word against hers is exactly that. The judge has to decide who to believe, and Practice Direction 12J framework tends to give benefit of doubt to the alleged victim. Let's talk about the strategic decision every father faces. Should you contest allegations in a fact-finding hearing, or should you try to settle? Arguments for contesting. If allegations are serious and false, allowing them to stand unchallenged means they are treated as fact. Your reputation with the court is damaged permanently. Any future application you make will be addressed in light of findings that you were domestically abusive. If you believe you can prove allegations are false, a fact-finding hearing gives you the opportunity to clear your name. Arguments for settling. Fact-finding hearings are expensive. If you're paying a solicitor, expect £5,000 to £15,000 by the time you get through fact-finding to the final hearing. They're slow, 6 to 12 months is typical, they're emotionally brutal, and the outcome is uncertain. Even if you defend yourself against most allegations, findings on a few incidents can still damage your case significantly. Here's my guidance on when to contest versus settle. Contest if allegations are serious and provably false, if you have strong documentary evidence contradicting her account, if her credibility can be seriously challenged, if you can afford the cost and the time, if the allegations would prevent any meaningful contact if they stood unchallenged. Consider settling if allegations are relatively minor, if the proposed settlement involves reasonable contact that you can work with, if you lack strong evidence to challenge her account, if the cost and delay of fact-finding would prevent you seeing your child for a year or more, or if expert advice is that findings are likely to go against you anyway. Settling doesn't mean admitting abuse. You can agree that there were difficulties in the relationship without admitting to coercive control or abuse. You can agree to measures like supervised contact initially without admitting they are necessary, framing it as a way to rebuild trust. The key is not agreeing to anything that locks you into long-term restrictions. If you decide to contest allegations, here's what you need to know about preparation. Start with the Scott schedule, go through every single allegation methodically. For each one, admit if it's true, deny it if it's false, or deny with alternative account if something happened but not as described. Be specific. Don't just write denied. Explain what actually happened. For denials, provide as much detail as you can remember. Dates, context, what led to the incident, what was said, how it ended, who else was present. The more specific you are, the more credible you are. Vague denials look weak. For alternative accounts, explain the full context. Yes, there was an argument about money, but here's what it was actually about, and here's the resolution. Yes, I questioned who she was meeting, but here's why that was a reasonable concern in the context. Context is everything in defending against coercive control allegations. Gather your evidence systematically, all text messages and emails from the relevant period, photos showing you engaged in family life, attending events with your child, involved in parenting, diary entries if you have them, bank statements showing shared financial decisions, not unilateral control, any evidence of her controlling behaviour towards you. Witness statements are critical. Identify people who observed your relationship and can provide evidence of the relationship being equal, not controlling, arguments being mutual when they occurred, your involvement in parenting and family life, her behaviour if it was controlling or problematic, the timing of allegations if they only emerged recently. Prepare your own witness statement. This needs to be detailed, chronological, and focused on the relationship dynamics. Explain how decisions were made jointly, how disagreements were resolved, what the balance of power actually was, how you were involved in parenting. Address the coercive control narrative head on by showing the relationship was not one of domination and subordination. Let's talk about common mistakes fathers make in fact finding hearings that make things worse. Mistake number one, getting emotional or angry. I understand the fury you feel when somebody is systematically mischaracterizing your relationship to take your child away, but displaying anger in the court confirms the narrative that you're aggressive and threatening. You must be calm, measured, and controlled throughout. It's unfair, but it's reality. Mistake two, focusing on proving she's a liar rather than proving what actually happened. Your goal is not to demonstrate she's a liar, it's to establish the truth. Attacking her credibility directly often backfires. Better to present your account so convincingly that her account is implicitly undermined. Mistake three, defending behavior that sounds controlling. If you're asked, did you check her phone, and you answer yes, but only because I was worried about who she was texting, you've admitted to checking her phone. That's what the judge hears. Better to deny if untrue, or if true, explain joint context. We had access to each other's phones. There was no secrecy or monitoring. Mistake four, minimizing or dismissing her feelings. Even if her allegations are exaggerated, dismissing her emotions entirely makes you look like you lack empathy. You can acknowledge that the relationship was difficult for you both, that arguments were stressful, without accepting that you were abusive. Mistake 5. Not addressing the coercive control framework directly. Judges are looking at patterns, not just individual incidents. Your evidence needs to show that the relationship overall was not one of coercive control. You need to affirmatively demonstrate joint decision making, mutual respect, equal power dynamics, not just deny specific controlling acts. Mistake 6. Over focusing on her behaviour at the expense of explaining yours. Yes, her behaviour is relevant context, but this hearing is primarily about whether you were abusive. Make sure you're spending more time establishing what you didn't do than what she did. Now let's address what happens if findings go against you at the fact-finding hearing. This is difficult but important. First, understand that findings are not the end of your case. The court then moves on to the welfare stage, where it decides what contact arrangements are in your child's best interests. Even with findings of domestic abuse, the court must still consider whether contact with you can be safely facilitated. Practice Direction 12J requires the court to consider the nature and seriousness of the abuse found, whether the abuse is ongoing, the impact of abuse on the child, your behaviour since the relationship ended, your willingness to engage with interventions like domestic abuse programs, whether there are protective measures that would make contact safe. This means your response to adverse findings matters enormously. If you continue to deny everything and show no willingness to engage, the court sees that as concerning. If you accept findings, express understanding of how your behaviour affected your ex-partner, and commit to programs or interventions, the court is more likely to allow contact to proceed. This creates an impossible position for many fathers. You've just been through a hearing where you contested allegations because you believe them to be false. Now findings have gone against you. Do you continue asserting your innocence, or do you strategically accept findings to move forward? There's no universal answer. If findings are based on clear errors or ignore strong evidence, you might appeal. If findings are mixed, some allegations proven, others not, you might accept what's been found and work to demonstrate change. If findings are comprehensive and you believe they are fundamentally wrong, you face a choice between principle and pragmatism. My guidance: talk to your solicitor about realistic prospects. If an appeal has decent chances, consider it. If not, Consider whether strategic acceptance of findings and engagement with interventions will restore contact faster than continued denial. Your goal is your child, not vindication. Let's talk about protective measures and what they mean in practice, because this is what happens after the findings. Supervised contact at a contact centre is the most common protective measure. You see your child for 1 to 2 hours at a time in a room with a supervisor present. You pay £30 to £50 per hour for the supervision, more in London. The supervisor writes notes about each session. After a number of successful sessions, the court reviews whether supervision can be reduced or removed. Here's the problem with supervised contact. It's artificial and constrained. You can't be a real parent in a contact centre. You can't deal with difficult behaviour, can't have private conversations, can't do normal family activities. The relationship remains superficial, and progression from supervised to unsupervised contact is slow and uncertain. Contact centres keep notes of any concerns. If your child is reluctant to engage, that's noted. If you seem frustrated or your child is upset, that's noted. Those notes go back to the court and can be used to argue that contact is not going well. You're under constant scrutiny. Domestic abuse perpetrator programs are often required before contact can progress. These are typically 20 to 30-week programs where you attend group sessions about abusive behaviour. You're required to acknowledge abusive behaviour, demonstrate understanding of impact, and show behaviour change. Completion is required before unsupervised contact. Here's the issue. These programs assume you were abusive. If you maintain you weren't, you can't complete the program successfully. You're required to demonstrate insight into behaviour you don't believe you exhibited. Many fathers find this psychologically impossible, but refusal to engage means contact stays supervised indefinitely.
Let's talk about how to challenge Practice Direction 12J findings or avoid the process altogether. Prevention is always better than defense. Before allegations are made, document everything. Keep communications in writing. Respond to all her messages promptly and reasonably. Never send angry or threatening messages, no matter how provoked you feel. Build evidence of your involvement in your child's life. Attend appointments, school events, activities. Get witnesses to your good parenting. If you see allegations coming, she's mentioned concerns to CAFCAS. Her solicitor has referenced domestic abuse in correspondence. Prepare preemptively. Gather your evidence before the Scott schedule arrives. Get character references written. Identify witnesses. The moment allegations are formally made, you're in reactive mode. Better to have evidence ready. If allegations are made and Practice Direction 12J is triggered, act quickly. Instruct a solicitor if at all possible. This is not the time to represent yourself if you can afford help. The process is technical and adversarial. A solicitor who understands PD 12J is invaluable. Review the Scott schedule with your solicitor carefully. Identify which allegations are most serious and focus your defense there. You don't need to win on every point. If you can successfully defend the most serious allegations and provide context for the rest, that limits the damage. Consider whether early concessions might avoid a full fact-finding hearing. If there are 1 or 2 allegations that you cannot credibly deny, admitting those while contesting the more serious ones might be strategic. This shows honesty and prevents the hearing from becoming entrenched warfare. If findings go against you, consider whether an appeal is viable. Grounds for appeal include: the judge made an error of law. The judge's decision was outside the range of reasonable decisions. New evidence has emerged. Appeals are difficult and expensive, but sometimes necessary if findings are fundamentally flawed.
Let me be direct about systematic problems with Practice 12J that need to be understood. Problem 1. The framework assumes credibility of allegations. Whilst technically the burden is on the mother to prove abuse on balance of probabilities, in practice, the framework's emphasis on believing victims and not re-traumatizing them means allegations are treated as credible unless you can disprove them. That's a reversal of the burden of proof. Problem 2. There's no penalty for false allegations. If a mother makes numerous allegations that are found to be untrue or exaggerated, there's rarely any consequence. The court might note her evidence was unreliable, but she won't lose contact or face costs awards. This creates asymmetry. Fathers risk everything by allegations, mothers risk nothing by making them. Problem 3. The coercive control framework is too subjective. As we discussed in episode 9, if controlling behaviour is defined by the victim's feelings of subordination, and those feelings are treated as evidence, how do you defend against subjective allegations? You can't prove you didn't make somebody feel controlled. Problem 4. Fact-finding hearings don't actually find facts. They find that on balance of probability something probably happened. That's not the same as establishing truth beyond doubt. Yet those findings are treated as established facts for all future proceedings. A 51% likelihood becomes absolute truth. Problem 5. The process is the punishment. Even if you ultimately win a fact-finding hearing, you spent a year and thousands of pounds getting there. You've been separated from your child during that time. The process itself achieves what false allegations aim to achieve: delay and disruption of contact. These problems are not easily solved. They're baked into the system. Practice Direction 12J was created with good intentions to protect genuine victims of domestic abuse, but the reality is now a procedural weapon that disadvantages fathers regardless of the truth allegations. So what's the bottom line for fathers facing Practice Direction 12J? Understand that if domestic abuse allegations are made, you're entering a parallel process that takes over your entire case. The fact-finding hearing becomes the main event. The contact arrangements are put on hold until it's resolved. The process is long, expensive, and heavily weighed against you. Document everything from today. If allegations haven't been made yet, behave as if they will be. Keep all communications written and reasonable. Build evidence of your parenting involvement. Get character references. Create the evidential foundation you'll need to defend yourself. If allegations are made, act quickly. Get legal advice. Prepare your defense systematically. Make strategic decisions about what to contest and whether settlement might be better. Don't let anger drive your response. If findings go against you, focus on what comes next. Your goal is your child, not vindication. If engaging with interventions and accepting findings moves contact forward faster than appeals and continual denials, consider that option carefully. And most importantly, understand that Practice 12J is a systematic issue, not a personal failing. Thousands of fathers face this exact process. Many navigate it successfully. It's difficult, unfair, and biased, but it's not insurmountable. In the next episode, we'll look at Section 9114 orders, the restriction that prevent you from making further applications without court permission. These are imposed alongside domestic abuse findings, and they create additional barriers to restoring contact. If you found this episode valuable, please share it with other fathers who need this information. The system won't educate you about Practice 12J, so we educate each other. This is general education about family court proceedings. It is not legal advice for your specific situation. If you're facing Practice 12J proceedings, consult a qualified family law solicitor. I'll see you in episode 8.